practice for 30 years, special. Anybody has questions at the end of the presentation or during, if you have questions during, you can type them in the message box that's on the screen to the right, and we will get to them at the end of this presentation. It'll also allow people to click the raise your hand button, and then we'll be able to open up audio for you to ask the question verbally. So with that, I'll turn it over to Jeremy.
Thank you, Bob, and thank you to all those who are attending today's session on buying or selling a pathology practice, what you need to know. So this is designed to give you an overview of some of the key issues you need to consider, whether you're a buyer or a seller, so that you'll be well prepared if that option becomes available to you. Just a slide about where our firm is located and how you can reach us. And let's get into the introduction of our topic today. So we'll cover who's selling practices and why, who's buying practices and why, what do buyers find attractive and they're looking for a practice to purchase. We'll go over what the acquisition process consists of, so you'll have kind of a soup to nuts understanding of how that operates. Talk about key deal points and key contract terms, some of the unique challenges if you're in a merger situation, and then we'll wind up with a little time left for questions. Okay, who's selling pathology practice today? Well, it really comes in all types: small solo practitioners, small groups, and larger groups of pathologists. Nothing surprising there. Why are people selling their practices? Well, it may be that if you have hospital contracts, your hospital is being bought out by somebody else, and you need to join with another practice that's currently serving the buyer hospital or hospitals. Declining reimbursement, something that everyone in the healthcare world is facing today, and it's no exception for pathologists. You all know how you're being squeezed on your Medicare and other and managed care reimbursements, and so that's one reason why people are considering selling out. The cost of operating your practice, while reimbursements are going down, unfortunately costs are going up, and people often need to try to reduce that overhead. Compliance burdens, we've got fraud and abuse, Stark laws, HIPAA, labor and employment laws. The list is endless, and it seems to keep growing every day. Many pathologists are getting tired of having to manage their own smaller practices or even some larger ones. They're looking for someone else who might be able to help carry that load. The market itself is becoming more complicated as payments and managed care shift things to a value-based system away from a strictly volume-based system. Additional reasons, people are maybe losing market share to larger competitors, larger labs, larger groups, and they feel they cannot continue to compete in the market. There's a need for capital, for expensive new sophisticated equipment for the lab, and that may be something that the group doesn't feel they can afford to borrow or want to come out of pocket for. If you're trying to add new subspecialties, maybe in the genetic or molecular testing field, and you don't have a way to do it within your current group, but you may feel you do if you sell out to a larger organization or larger group. Similarly, a larger purchaser may be able to help you recruit those people or those pathologists with specialties that you don't have, or even for general pathology where you just can't compete with large organizations and offer attractive enough packages. A sale can also possibly be a so-called capital event where you actually make money on the sale if you're so fortunate. Or you may have a situation where as a seller you have obligations to partners who are going to be retiring shortly, and based on your buy-sell agreement you have a pretty substantial financial obligation to pay those retiring physicians, but you don't really have the wherewithal to do it. Let's go now to who are some of the buyers and why are they buying. Well, certainly pathologists, other pathologists and pathology groups are buyers of other pathology practices. Sometimes hospitals or hospital-controlled medical foundations are doing the buying. And you have regional and national chains and players who are certainly among the buyers, including organizations like Quest and LabCorp, with which you're all familiar. Private equity considers pathology to actually be a good area because there's an increasing need for tests. So you have some private equity folks who are also buying practices, although in California they have to form what's called a friendly physician corporation to do the actual acquisition of the professional practice side. They can't operate the lab side directly. There are some public companies that are in the market as well, including Quest and LabCorp. Over the last 5 years, there have been more and more purchase and sales of pathology practices and labs. That pace expected to continue to be robust. Why are people interested in buying your pathology practice and possibly if you have your own lab? People are looking to increase their test volume. So if you're a pathology practice which has good contracts and good referral sources, that would be one way if you're a buyer to increase the size of your footprint. Achieving economies of scale, given the increasing cost to operate a practice and the reduced reimbursement rates, it's very helpful to a buyer if they can aggregate additional practices, start reducing redundant, maybe a difficult word to hear, redundant personnel, and to centralize various services so that overall practice overhead can be decreased. The buyers may have a need for specialty types of labs that are listed or different kinds of specialists, and they can do that more easily by buying existing practices with those specialties rather than trying to recruit new people. It may be a way for a buyer to obtain the hospital contracts, for example, that the selling pathology practice may already have. Sometimes the desire is for pathology practices which have managed care experience and have real physician leadership, and that's one way to acquire that leadership. Increasing market share and therefore negotiating power with the payers is another common reason for practice acquisitions. The goals of buyers and sellers don't necessarily have to be identical, but they certainly need to be compatible or congruent. Otherwise, there's going to be a mismatch. What are some of the things that buyers find attractive about a pathology practice and lab that would make them interested in your practice if you're in the potentially in the selling mode? Well, they will often view the purchaser, or the seller rather, as someone who can help to achieve their strategic goals, some of which we talked about earlier, such as increased market share, adding specialties, physician leadership, and the like. It's very important for the buyer that the selling practice be compatible in maybe some of these areas that seem a little softer, but what is the corporate culture of your practice? Is it consistent with that of the buyer? Do you have a similar work ethic? Are people very productive? Do they have the same quality standards? Are they very concerned about compliance? Are they well organized? Things of that nature, all going into how your business operates, and are those going to be compatible? It's very important to a buyer that they wouldn't be inheriting problems if they buy you out. So are there any approvals that have to be obtained by from any government agency to buy your practice? Or do you have any existing compliance problems in the billing area or HIPAA or labor and employment that would be something that would turn a buyer off? Being well organized when you're considering selling yourself will be attractive to a buyer rather than when they ask for documents and relevant financial information, people are scrambling around, or worse yet saying we don't collect that data or our data is not reliable. Obviously that would be a turn-off to a potential buyer. They want to buy a practice that seems to be operating well. Another attractive feature to a potential purchaser is if they can retain the key physicians and management and other staff members and technologists and the like, and that's often a point of discussion because they think they're going to lose all the physicians or many of the physicians who are the source of referrals and goodwill or key lab managers, then clearly that makes a practice less attractive. Continuing on as to other factors about your practice would make you attractive or not if you don't have these factors. Having strong physician leadership and strong managers and people who, as we discussed a moment ago, who will stay with the practice. There are occasions when certainly a buyer will implementing your electronic health record system and it's functioning well, and that it'll ultimately be compatible with the purchaser system. If you have managed care and care coordination experience and are getting involved with value-based purchasing, then you're also going to be looking more attractive. The last bullet point speaks to the issue that if there in fact is a schism or a strong difference of opinion within the group whether to sell or not, then that's going to spook a potential buyer. I want to make a slight distinction between the traditional buying and selling and a merger. When I use the term merger, even though mergers are still acquisitions of stock of a practice, I'm using the term merger in the sense of two groups, not necessarily of the same size, but roughly viewed as equal players, and they're trying to determine whether they should group together to present a stronger combined organization rather than one group clearly being bought out and having to adjust to the rules, regulations, and culture of an acquirer. So if you have a potential merger situation, you need to make sure that your goals for merging are compatible. For example, if one group is saying our real purpose in merging is we're working to where we want to work less, and your potential merger partner's goal is to say we want to get busier and expand our test volume, that sounds like something that's not compatible. Your corporate cultures, do you have similar work ethics? Do you have similar views about quality? Is one group a little more staid, the other more aggressive? These are the types of things that need to be explored so that you'll get along if you in fact merge. Productivity, if it's roughly equal or if it can be adjusted in the compensation formula, will be something that's necessary. Obviously, if one group is much more productive than the other, then that suggests there can be a problem. Similarly, compensation is, and that's related of course to productivity, is that something that is very different between the groups, or the groups roughly equal in what they earn? If they're not, then that will be maybe difficult to reconcile. Benefits that you get, whether it's health insurance, retirement benefits, time off, those need to be considered. The personnel, as I indicated earlier, one of the reasons that people are combining is to try to reduce their overhead through economies of scale, so that means that there may be layoffs, and whose personnel will be laid off. Electronic health records, whose system is going to be adopted if you don't have the same electronic health record system. And if one group has invested a lot of time and money and aggravation in adjusting to their EHR system and now have to learn a new one, that could be a problem. Additional merger challenges include whether the groups have the same contracts with PPOs, IPAs, and the like, or not. Will it actually allow groups to extend to certain payers they don't currently have? And if they do have the same payers, will one group's rates be higher than the other, and can the lower paid group piggyback and get the higher rates, or vice versa? Governance in any kind of merger situation is going to be a very important issue. That basically means control and how many votes people have. Will it be 50-50? Will it be that voting isn't really based on which group you came from, with just one person, one vote? Those issues have to be addressed. Is there any debt that either of the two practices have? It could be more than two practices that are merging. But if there's any debt, how is that going to be addressed? Will it have to be paid off, or will it be assumed by the new merged group? Compliance risks, we touched on that earlier. Clearly, for someone considering merging with you. If they think your group is, if you have an OIG investigation or you have HIPAA violations or other problems, then that will be of concern. Age differences, if in one group the doctors are earlier mid-career and the other group has folks who are closer to retirement, then that can certainly be an incompatibility. Tax planning will relate to whether there will be any taxable event happening as a result of the merger. And retirement plans, if one group has a very generous retirement plan, the other group has no retirement plan at all, how are you going to reconcile those? So those are some of the particular challenges that one faces in a merger situation. If you're in a straight purchase and sale situation, then whoever's doing the purchasing, those who are selling will have to adopt to the purchaser's salaries, compensation, benefits, and the like. Let's go over what the acquisition process consists of, so that if you're contemplating selling or buying, you get some big picture idea of what is involved. So the first step is, whether you're a buyer or a seller, is to assess what your objectives are in buying or selling. What are you hoping to achieve? Sometimes it's less clear than you think, or the physicians in the buying or selling practice actually may have different points of view. So you need to really be clear on what you hope to achieve. And sometimes you'll find when you scratch deeply below the surface that the ideas and goals either are not clear, they're not shared, or they may not be realistic. Once you've agreed that you can speak with one voice and you know why you want to buy or sell, you need to assemble your team that will be in charge of the acquisition process, whether you're a buyer or a seller. That team will include one or more physicians who are in a leadership position. If you have a chief executive officer in the practice or other senior manager, that person should be on the team. And then a little more in the background, your practice accountant and your attorney. I mentioned investment banker. There are some practices, when they're a little larger in size, that will actually retain an investment banker to help to market the practice and help in the sale process. Continuing on with the overview of the acquisition process, you'll want to do some tax planning and analysis to determine how you need to structure a sale, so that hopefully, if you're the seller, you can reduce your taxable gain, if there is any gain, and if you're a buyer, you're going to want to also have the assets in a situation where you have a high basis, so you have a lot to depreciate, as opposed to something that can't be depreciated. There also can be issues if you're a corporation that's selling its assets, and if you're not what's called an S corporation, but you're a standard C corporation, there may be issues to how to get any purchase price paid out to the owners of the practice without paying a corporate tax. We'll talk about that a little more later in the presentation. If you're the seller, then it's going to be primarily your job to assemble due diligence information so that the buyer gets to know what your practice consists of. You'll want to make sure your financial records and billing information are well organized, so that when a potential buyer comes looking around, they're all going to ask for this information, and you want to be able to provide it readily. Similarly, you want to make sure your operational matters are in good shape, so that people don't get the wrong impression if you're a seller about how you operate. Similarly, for legal compliance, that you have your legal house in order. How does a buyer get found in the acquisition process? Well, it may just be people who know each other through professional societies or the like, or through trade organizations, and the buyer may approach you as a possible acquisition. There are practice brokers who go out and look for acquisitions, as well as practice brokers who represent selling practices who go out looking to market the practice. Investment bankers we mentioned, they do the same thing at a little more intense level. If you're fortunate, you'll have multiple people bidding on your practice, because that will enable you to get the best possible price. How do you go, and then part of the process is evaluating any bids that you get. And it's not always that the best deal is the highest purchase price. If you're in a situation where you're selling your practice, but able to close the transaction at the same kind of speed with which you would hope it to be able to close. Continuing on in the acquisition process, once you have in effect located a prospective purchaser and you and the purchaser more or less agree you want to do business together, then the next step in the process is to prepare what's known as a letter of intent. And the letter of intent typically covers the items listed on this slide. So it covers how the deal is being structured. Is it a stock purchase or an asset purchase? It covers what is going to be acquired. Certainly in the case of an asset purchase, those are assets, but those then have to be delineated. Are any liabilities of the selling practice going to be assumed? What's the purchase price? How is that going to be paid in cash or partly cash, partly in installments? The letter of intent will say that ultimately the purchase and sale documents will have standard representations and warranties by the sellers and other covenants and conditions. It should address whether there is going to be post-sale employment so that the selling physicians know that that's part of the deal. It should include a provision, if you're the seller and the buyer, actually more from the buyer's perspective, that while you, the buyer, are going to be going through a lengthy due diligence process and negotiations, you don't want the seller to be able to continue to try and market the practice to other potential buyers. Obviously, as a seller, you'd like to retain that flexibility, but typically it's customary that there's an exclusive dealing period that might be 60 days, 90 days, 120 days, and sometimes that will be renewed. The letter of intent will say that the terms that are confidential, and typically it will say that it's not binding except for a few terms such as confidentiality and returning documents to each other if the deal doesn't close and things of that sort. Letters of intent sometimes can be relatively short, a few pages long, maybe even bullet points. Other times they can be quite detailed. As part of this process, you have to decide how much of the deal you're going to want to negotiate in the letter of intent, which they say is not a binding document, versus how many of the details you want to leave till the actual purchase and sale agreements are prepared. People sometimes get carried away and they they spend so much time in the letter of intent, it seems they never actually get to the purchase and sale agreement. So you have to strike a balance there. Due diligence, a critical part for the buyer in an acquisition. It's really the buyer who's most concerned because the buyer wants to make sure they're getting what they paid for. The buyer doesn't know your business. You know your business if you're a seller. So the buyer is trying to understand what the seller's business is about and to verify financial and other information, billing information, collection information, compliance information. They want to make sure that it's really correct. So if the seller says, we have 3 hospital contracts, exclusive contracts, the buyer is going to want to see copies of those contracts and see if that's true, see how long the terms are of those contracts, how quickly they can be terminated, things of that nature. The buyer is going to want to see your financial information, tax returns, and your various contracts. The consequences of the due diligence process can be that the buyer is satisfied and says that sounds like everything checks out and the practice is as you've represented it to be, or it may be that the buyer finds something, and this is certainly not uncommon in the due diligence process, and says, well, we didn't realize that you have this problem, so we need to adjust the terms. Maybe we need to adjust the purchase price or have a holdback from the purchase price. Or if things get serious enough, as a result of the due diligence process, the deal may never come to pass. I know I was involved in a large acquisition not involving a pathology practice where in the course of the due diligence we determined there was a very significant Stark problem which could have resulted in a multi-million-dollar payment being owed to the government, and that helped to kill the deal. Business due diligence relates to the due diligence focusing on your things like your payer contracts and the financial information, billing information, whereas legal due diligence is focused on compliance issues, ability to assign agreements to the buyer, whether there's litigation, are there liens on the property that's being sold, are there Stark problems, and things of that sort. The last bullet point about creating a document room in this day and age, unless it's a very small practice purchase, the way the due diligence process is handled is that the selling party, selling practice, will put all its documents in a virtual space on the internet or in the cloud with password protection and encryption and the like, and then the buyer and the buyer's attorney and the financial advisors can then access those documents rather than having to constantly ask for documents. The document room is populated with all of your relevant documents. Continuing on in the acquisition process, once the due diligence is complete and satisfactory, then the parties go to preparing what are referred to as the definitive acquisition documents, and that consists of the purchase agreement. There could be consulting agreements for people who will be staying with the practice only on a part-time basis, employment agreements if you are going to be continuing as a seller with the purchaser, then those employment agreements need to be prepared. A bill of sale is what's used to convey title to the assets to the buyer. Promissory note if part of the purchase price is going to be paid over time. A security agreement, which the seller may say that they're not comfortable just relying on the promise of the buyer to pay. They want some assets to back that up. And then there have to be various shareholder and board approvals from the buyers and the sellers. Last slide on the acquisition process. There'll be corporate resolutions. If you're incorporated, that will have to be prepared to authorize the sale. The parties will get what are called good standing certificates from the Secretary of State's office to show that their corporations are not impaired. You'll have to get various consents from some maybe for office leases or hospital contracts and payer contracts and the like to be assigned to the purchaser. Lenders, if there are any, may get paid off out of the purchase price. And then finally the documents are signed and then exchanged between the parties. I guess I saw one more slide here on closing the deal. The purchase price, of course, gets paid. Often that's done by a wire transfer or it could be exchange of a bank check. Title to the assets or shares is conveyed. The employees of the selling practice have to be terminated and paid out their PTO on the closing, even though the employees may be hired back by the purchaser. And then there may be some adjustments for after the closing for some bills that come in that partly relate to things that went on prior to the closing as well as after closing, such as utility bills. And then the patients need to be notified of the change as well as certain vendors so they'll know who they're going to be dealing with. Okay, we're going to talk about the key deal points. I'll go through these a little more quickly because many of these are going to be covered in the letter of intent, but we want to make sure, if we didn't cover some of them, that everybody's aware of what some of the key points for negotiation are. The first issue is, will the deal be purchased or structured as an asset purchase, where if you're a corporation and you're selling, the buyer is going to be buying your furniture, your equipment, your supplies, your goodwill, things of that sort. In a stock purchase, which is much less common than an asset purchase, the buyer is buying your shares of your professional corporation, and the buyer takes whatever's in that corporation, including the liabilities. So there aren't that many purchases that happen that way because buyers are concerned about inheriting liabilities that they don't know about. The purchase price obviously is a key deal term, and people naturally want to know what their practices are worth or how they find out. In many purchase and sales, people have their own idea of what they think they're willing to pay, and the sellers have their idea of what they're willing to sell at, and the parties negotiate that. Sometimes the parties will only use a valuator, particularly if there's a hospital involved, to confirm that their price is fair market value. To goodwill and non-competes, then the seller may be able to get capital gains tax, which obviously is an advantage to the seller, but the buyer's going to have their own interest in that because that will affect the buyer's future tax position. Assumption of liabilities, clearly the parties want to know if the seller has debts, loans, leases, maintenance contracts, and the like, which ones are going to be taken over by the buyer and which ones are going to be left with the seller. Tail insurance, this will be for the seller. Whether if the buyer has a different insurance malpractice carrier and the seller is going to have to terminate their policy, will the seller be totally responsible for that, or will the buyer be able to help out at all? Will any of your staff be retained? Frequently the sellers do want to negotiate for having non-physician staff retained and not have to look for new jobs as a negotiation point. Custody of medical records, if the old practice or the selling practice is going to be effectively going out of business and they're not going to be hiring in the new practice, but the new practice will not be hiring in the seller's physicians, then who will take over custody of the medical records? Indemnification we'll talk about a little more later. Restrictive covenants, those are those non-compete agreements, and what restrictions will the sellers have after the sale on potentially if they're not happy with the buyer after the sale going out and starting their practice back up again. And the last point on this slide is the negotiating what kind of post-sale employment or consulting agreements the seller physicians will have. Okay, let's move to what are the key terms in the contract. Again, many of these will be items that should have been addressed to some extent in the letter of intent as they are key deal points, but now we're talking about those long contracts that lawyers specialize in that can be 30, 40, 50 pages or more, and now it gets down to the dotting of the I's and the crossing of the T's on deal points that may have only been covered in a more broad sense. But in any event, the purchase and sale agreement should be based on what that letter of intent said, and it shouldn't be a situation where you're negotiating all the deal points when you get to the purchase and sale agreement point. So the purchase and sale agreement should include, if you're the buyer, an exclusive dealing period whereby as the buyer you know that while you're negotiating the purchase and sale agreement, the seller is not going and continuing to shop the practice. There'll be a section in the purchase and sale agreement where various terms in the agreement will be defined. One of the most critical terms is what's called the definition of knowledge, because when we talk about representations and warranties that the seller is going to have to make to the buyer about the state of the practice, many times the seller will say, well, this is to our knowledge. We're not saying that it's 100%, we're 100% certain, but as far as we know, and we haven't done any extra checking, this is what we think is true. So that's going to be a point that will be negotiated. Clearly, the purchase agreement needs to identify exactly which assets are being purchased as well as which assets are being excluded. For most sellers, if it's an asset purchase, they're going to say, we'll keep our cash, we'll keep our accounts receivable, and we're just selling you the physical assets plus the goodwill. Assume liabilities. From a buyer's perspective, the buyer will say, we want to buy the assets. We don't want to assume any of your liabilities, but of course there may be exceptions. There may be office leases and other contracts that are a form of liability that the buyer will be willing to assume. Those need to be clearly defined, as well as the liabilities that are excluded. Of course, the purchase price will be set forth now with great specificity. In almost all cases, the purchase price will be a fixed amount of money, rather than a purchase price that may vary depending on how the practice does after the sale. How the purchase price will be paid out, again, will it be all in cash, or will it be some of it paid out in a note? If there will be a note, over how many months or years will that money be paid out? Will there be an interest rate? Will there be a security agreement for the note? Will there be any use of an escrow for paying the purchase price? Those things are all going to be covered in the purchase and sale agreement. In addition, the purchase and sale agreement will cover the allocation of the purchase price, which I mentioned earlier, relates to if the purchase price is $1 million, how much of that's for goodwill, how much of that is for covenant not to compete, how much is for furniture, how much is for equipment, and the like, and that has different tax implications. It's also very important if you are a C corporation as a seller, not an S corporation, and those are RS designations. When you sell the assets of the practice, then the buyer pays the money into your corporation. So it's always a challenge if you're a C corporation to try and get that money out to the seller shareholders of the C corporation in a way that won't first be taxed in the corporation. And sometimes that's not easy to do. Seller representations and warranties. These are the things that the seller is going to want to have the buyer, the buyer is going to want to have the seller represent to the buyer about the practice and the state of the practice, because the buyer's interest is in not having any bad surprises. So they're going to want to have the sellers tell them all sorts of things about what the practice consists of. Did the sellers have the authority to sell the practice? Is all the financial information accurate? Are there no tax problems or labor problems or billing issues? Is there any litigation? Are there any government investigations? Are all the contracts currently being performed, or are there any alleged breaches of contracts? Do you have title to all of your assets? Do you have all your licenses and permits? So these are all things that the purchaser is going to insist that the buyer tell them and represent and warrant and promise that these things are all in good shape, unless there are exceptions, which then are included in the purchase agreement in the form of a schedule. That doesn't mean the buyer will accept those exceptions, but if they are accepted, then they need to be outlined with specificity. The buyer, on the other hand, really doesn't make too many representations to the seller. The seller wants to make sure that they get paid. The buyer is really not saying much more than they have a right to enter into the agreement and they can perform the agreement, and that's about it. Pre-closing covenants, you may sign the purchase agreement, let's say on June 1, but the sale may not be set to close until July 1 while various things are getting taken care of, such as getting consents from lessors and vendors and the like. During that period, the buyer is going to want the seller to represent that they will maintain the business as it's been maintained and not do something, incur debts or cancel contracts that are important to the practice. Pre-closing conditions, this will be set forth things that have to happen before the buyer or the seller are obligated to go and complete the deal. This could include obtaining consents from the landlord for the office lease, from various important payer contracts, that the various documents will be delivered, that the due diligence will be completed and the buyer will be satisfied with it, that any financing that the buyer needs will be obtained, and that there have not been any adverse changes to the condition of the practice since the purchase and sale agreement was first signed. The closing date, the purchase and sale agreement will state when the deal is supposed to be completed, and usually it will state a date, and then it will say that if that date's not met, there'll be another, let's say, 30 days to close the deal, and if the deal is not closed on that date, then the buyer or the seller can walk away from the deal, although more typically, if the parties are making good progress, they'll just agree to extend the date. Continuing on with key contract terms, there'll be provision in there for under what circumstances might the purchase and sale agreement be terminated even after it has been signed. It can be terminated if certain key conditions aren't met that would be set forth in the purchase agreement, or, for example, if the parties don't close on time. Restrictive covenants are extremely important and often misunderstood. Many of us in California have heard that non-competes are not enforceable. That is true if you're employing a physician. If we've breached any of our representations to you about the condition of our practice, if it turns out the financial information we provided was not accurate or was incomplete, or we've told you that we didn't have any litigation in the practice, or there were no government investigations, and one or more of those representations turn out not to be true, then the buyer is going to want to have a promise by the sellers that they will indemnify or pay the buyer for any losses the buyer will incur for taking on unexpected liabilities. So that clearly is something that the sellers are going to be concerned about, because they want to get paid their money. They don't want to have to look over their shoulder and be concerned they're going to have liabilities after the sale of the practice. So those are going to be, those indemnification provisions will be very very heavily negotiated from a seller's perspective. The seller may say, well, first of all, I want to make sure my representation warranties are only to my actual knowledge, so that if it turns out not to be true, but the seller was being honest, even if they were wrong, the buyer can't require indemnification. Or there may be that the seller will try to get what's called a basket and a cap, so that if the amount of any breach of the representation involves a modest amount of money, maybe less than $5,000 or $10,000, the buyer cannot keep nickel and diming the sellers to pay that. And more importantly, the sellers may say, we can't have unlimited liability. We're willing, for example, to be liable up to a maximum of the purchase price that we receive, but if the liability is greater than that, we won't be responsible. And those are typically negotiated, those caps. And another issue for the sellers will be whether each seller, if there's multiple shareholders, will be liable for the whole purchase price jointly and severed with the others. So if one of the selling physicians is well heeled and the others aren't so well heeled, will that seller potentially be liable for the whole thing, or will the liability be individual to each seller, so they each take 20% of their 5 sellers of the potential indemnification obligation? Post-closing covenants, sometimes there are things that need to take place after the sale. Maybe there will be consents that can't be obtained before the sale, so those are going to be specified in the purchase and sale agreement. There'll be a dispute resolution mechanism, so that if, unfortunately, after the sale, there's some disagreement about whether both one party or the other has lived up to its obligations under the agreement, how will those be resolved? Typically, we like to provide for a mediation provision so the parties can informally try to work out a settlement But if not, then the dispute resolution mechanism would indicate whether the remedy is to then go to court and sue, or whether to go to arbitration as an alternative. Arbitration can be a good thing. It can be something that is a little faster, a little less costly than going to court. It's generally confidential, and the results are final, meaning they can't really be appealed except in very rare circumstances. The flip side of that is arbitrations are not necessarily either fast or cheap as compared to going to court, and the finality of the arbitration decision is a great thing if you prevail in the arbitration, but if you lose, then you don't have any recourse. Okay, our last section will be on what can be as important, if not more important, to the sellers and the buyers than the purchase and sale agreement and the purchase price, and that is if you're selling but planning to join the group who's acquiring you. So this will mean that you'll have either a consulting agreement, usually which is used as a short-term transitional agreement, or if you're planning to join full-time, then you would typically have an employment agreement. And even if you're going to be an owner of the new corporation that's buying you out, which sometimes is the case, you'll still have an employment agreement. So any employment agreement needs to cover the items listed on this slide, clearly set forth what your duties are, how you'll be compensated, what kind of benefits you'll be eligible for, time off, will you be covered for malpractice, and if so, for tail insurance, how long will the term of the agreement be, and when can it be terminated. There are certainly situations, this happens a lot with hospital acquisitions and larger companies, where they'll say, yes, we'll give you a 3 or 5 year employment agreement, but then you look at the fine print and they have the right to terminate the agreement at any time with or without cause on 30 or 60 or 90 days notice. So that's going to be very important, particularly if a lot of you think the value in the sale is in this employment agreement with the new organization. Restrictive covenants. There can be other restrictive covenants besides non-competes that may be enforceable, as far as not soliciting the business of the practice if your employment is terminated, and dispute resolution, really the same kind of provisions that we discussed in the purchase and sale agreement. So in conclusion, as I mentioned at the outset, there is a fairly high amount of activity in practice purchases and lab purchases and sales, but each deal is unique. There are no cookie-cutter situations. If you're the seller, primarily your objective is to get paid, and if you're going to be employed, obviously to get a good employment agreement. If you're the buyer, you of course want to get what you're paying for and not have any bad surprises. These transactions can be quite complex, and they can take many months to complete. And when I say they can be expensive, there are, if you use a practice broker, obviously you can use an attorney and an accountant, and there are costs to those transactions. Very, very important to proceed in an organized manner with your team being organized and your documents being organized and having realistic expectations. Finally, buyers or sellers rather should know that if the process drags on, usually that's not going to be in the seller's interest. It means there's a problem. You may get the purchase price knocked down, so you want to again be prepared and organized so you can proceed in a very efficient manner. And that concludes my formal remarks. At this point, I'll turn it back to Bob Ackerman to see if there are any questions from the participants.
Yeah, if anybody has any questions, you can type them in or raise your hand. I do have one that was submitted already, and the question is, how does one go about evaluating the pathology practice? What about concerns many of the referrals may leave once the selling pathologist departs?
A very good question, and if I was going to guess what question would be asked, it would be, how do you determine what you can get for your practice? The buyer is going to be, of course, concerned if there's going to be a loss of referrals. That's going to cause a reduction in the purchase price. And if you hire a practice valuator to value your practice, then that is going to be a key issue that the practice valuator will consider, whether those referral sources will likely, if this is the case of the seller retiring, will likely continue to patronize the buyer. If they're not, then there may not be a lot to sell. But it may be that, in fact, if the seller is selling to a buyer who's well qualified and can do an excellent job, that you'll be able to convey that goodwill, and you'll be able to get your price. But if there's a real question about I think the pace has been pretty robust and will continue. And as far as who's selling, because there are more smaller practices, there are more smaller practices being sold. They're just, as you go up the pyramid, there are fewer larger practices. But so I think we see it of all sizes, but they're just, the volume is probably higher for the smaller practices.
Okay. Does anyone have any questions they want to pose? If not, I want to thank the participants for being a part of the webinar today. I want to thank Jeremy for an excellent presentation, very thoughtful, and a subject that can be difficult and has a lot of aspects to the process, negotiation, and determination. So I want to thank you all and wish you a good afternoon.
Thank you.